This We the People News, not an attorney, not giving legal advice. Okay?
As the alleged defendant. This fact alone is enough to prove that this is a municipal court and must see all before it as federal citizens and foreign aliens. The plaintiff in your court is a municipal corporation called the state of Idaho and not the people of Idaho. The representative of the plaintiff is the district attorney, a corporate attorney for the state of Idaho, and not a public prosecutor as constitutionally required to prosecute a state-only citizen like the alleged defendant. Your court only recognizes the due process rights according to citizens of the federal government. It does not recognize the due process rights of someone like the alleged defendant who is only a citizen of a state. For instance, your court does not recognize the right to a jury trial, much less a trial by jury as mandated by the Idaho Constitution for someone like the alleged defendant. Your court is deemed to know that not every citizen is a federal citizen, and therefore you lack jurisdiction over most of the people that come into your court, and yet the question of jurisdiction is never raised. Your court, the plaintiff, and this prosecuting attorney keep this lack of authority completely secret, and people do not not subject to this court's authority are tried and punished on a regular basis. This speaks loudly about the inherent integrity of your court system. If there was a complete integrity on the part of all the judges in your court system, the first three sentences would be all I would need to state in order to cause the judge to immediately defer to the DA to determine if my denials could be overcome with facts to the contrary, and if not, the judge would immediately dismiss the case for lack of jurisdiction, and it would be evident to them that they have no authority to move to examining the facts, much less authorize further incarceration of my.
And what is the nature and the cause? And the jury is to judge the law and the facts. They got to judge the law. Is that a good law? Do they want that law applied to them? They got to judge the law and the facts.
Body. I don't expect that to happen, so further material relevant to the fact that this court lacks jurisdiction over me is provided. This guy's pretty sharp, I'm telling you. There's 3 documents he files. This is one of them. This is a 14-pager. Some of the other ones are shorter. They're quite brief. But this one, actually, alleged defendant denies that the plaintiff stated a fact upon which relief can be granted. I'm just going to check online and see what's happening. See, but when you argue this stuff, you cannot argue the other stuff. Okay, you're arguing strictly law. You're saying that your statutes are void of vagueness and therefore don't mean anything. See what I'm saying? Anyways, alleged defendant denies that plaintiff stated a claim upon which relief can be granted. That's paragraph 6. If the record does not show upon its face the facts necessary to give the court jurisdiction, they'll be presumed not to have existed. That's Ex parte Kearney, California court case. Without a formal and sufficient indictment or information, a court does not acquire subject matter jurisdiction, and thus an accused may not be punished for a crime. And that's Albrecht versus United States Supreme Court. John Smith alleges that that where a charging instrument does not clearly show facts necessary to give the court jurisdiction over the person, the court cannot proceed to examine the facts and must dismiss. Since there are people in Idaho over which this court has jurisdiction, and there are people like the alleged defendant with that it does not, for an indictment or information to be sufficient, the instrument must clearly state the facts proving this court can assume jurisdiction over the person. This statutory provision merely codifies the well-established principle that the courts acquire authority to adjudicate a matter when they have both subject matter and in personam jurisdiction. People versus McFarlane. Establishing jurisdiction on the charging instrument. At this point, we must address what it takes to show facts necessary to give the court jurisdiction and create a sufficient indictment or information. Under the constitutional system, it has existed since the 14th Amendment was declared adopted on Thursday, July 9, 1868, two and independent distinct classes of citizens have existed in the several states. This is important information because each class of citizen is under a completely different system of law, and the rights constitutionally secured to them are very different. The original class of citizens, being only citizens of their respective state, made up of white citizens thereof, are required to be under a constitutional republican form of government, wherein the several states, the United States, only have those powers over them that are clearly delegated to those government bodies by the constitutions by which they were created. The U.S. Supreme Court, hereafter U.S. Supreme Court, has stated that the powers that these government bodies can exercise are absolutely limited to clearly enumerated powers, and those clearly implied as necessary to carry out the clearly enumerated powers. Before the adoption of the 14th Amendment, the conduct of the citizens of the states, being only white people, were only limited by scope by the regulatory powers clearly delegated to the state via the relevant constitution. No power to regulate their conduct that exceeded that authority could be exercised. The courts have clearly stated the 14th Amendment had no impact on the original citizens of the states. There are many citations on this available. This is true for two reasons. Number one, the constitutionally secured rights of white citizens of the several states, which are far superior in number to the rights secured to the new class of citizens, were already secured by their state constitution. As such, the original citizens of the states would have gained nothing from this new amendment, even if it had been able to attach to them. Constitutionally, Congress is without power to reach out to the states and make those people citizens of the United States. To impose a new federal citizenship created by the 14th Amendment upon the existing citizens of the several states, one would have stripped them of the vast majority of the rights secured to them by their states' constitutions. The U.S. Supreme Court has correctly made it clear that once rights attach, they cannot be diminished by any means. Due to this foundational constitutional principle, the original citizens of the states, as their posterity, retained all their rights their ancestors secured to them, and their posterity and those like them that had later immigrated to the several states. The fact that the municipal statutory trial courts are acting in a policy to ignore this fact does not change the constitutions and make their actions legal. Such actions are simply unconstitutional acts committed under color of law and authority. Citizens via the 14th Amendment. The federal courts, including the U.S. Supreme Court, have clearly stated citizens via the 14th Amendment are first and foremost citizens of the federal government. Their few rights arise only on the federal level. This is very important because the United States is under a completely different system of law from the several states. It is a system of law that, as can be seen in Article 4, Section 3, Clause 2, grants the United States almost unlimited regular powers over them. Okay, that's this Article 4, Section 3, Clause 2 that we talk about. This applies even if they're resident in one of the several states. The courts have made it very clear that unlike the white citizens of the several states, whose rights arise from the state constitution of their domicile, these new class of citizens derives no rights from the constitution of the state in which they reside. This means that even in the states, all the state has to do is avoid depriving of a limited form of due process before punishment, and avoid depriving them of certain other rights that Congress and the U.S. Supreme Court has declared to apply to them. Under these conditions, per Article 4, Section 3, Clause 2, the state and local governments are free to impose any law or rule upon them they please, even if they are municipal corporations, so long as the law or rule can be proven to be needful and not merely oppressive upon challenge. In the simplest terms, the limitations imposed on the several states and the United States via their constitutions over the white citizens of the several states are not binding upon the several states and the United States when making and imposing laws and rules upon citizens via the 14th Amendment and foreign aliens while in the several states. In fact, it has been held that the long arm of Congress follows us citizens even into the foreign countries, and the United States citizen can be punished upon their return for conduct that is legal in the foreign country if it is deemed illegal by the United States or a union state of their residence. System of law. The
Alrighty. Um, we need to go back to the original intent. And we need to go back to the original intent to clean the mess up due to violation even to the 13th Amendment, right? A statue is saying you can't walk across the street. When constitutionally speaking, you're not regulated. You can walk across the street. You govern yourself because you're one of the people of the state and federal government. Okay, you're the people. What they did is bound you into this lawless, unlawful conduct. Okay, to imprisonment you. So, don't know what to tell you any more than that, right? It's just you are being regulated. And if you are regulated, then you are not free. And if you're not free, you're enslaved. And you must bow down to the almighty lordship. This will be the People News. Bye, y'all.